Hello everyone, welcome to the channel No Spear. This is Sheshadri Kulkarni. In this video we are going to know about the Supreme Court of India, its powers and functions. The Supreme Court of India is the highest judicial court in India and the final court of appeal under the Indian Constitution, the highest constitutional court with the power of judicial review in Republic of India. It is the supreme judicial authority of India. The Supreme Court of India was established on January 26, 1950. The Supreme Court is in Delhi. History and background of Supreme Court of India. With the passage of the Regulating Act of 1773, the Supreme Court in Calcutta was established as a court of record with the full power and authority. It was formed to hear and decide all criminal charges and also to entertain, hear and determine all addresses and proceedings in Bengal, Bihar and Orissa. The Supreme Courts at Madras and Bombay were established by King George III in 1800 and 1823. The Indian High Courts Act of 1861 established high courts in different provinces and eliminated the Supreme Courts in Calcutta, Madras and Bombay, as well as the Sadar Adalats in presidency towns. Until the foundation of the Federal Court of India under the Government of India Act 1935, these high courts had the distinction of being the highest courts in all the cases. The Federal Court had jurisdiction to solve disputes between provinces and federal states and hear appeal against judgments from high courts. The Constitution of India came into existence from January 26, 1950 and Supreme Court also came into existence on the same day. The first sitting of Supreme Court was held on 28th January 1950. The law declared by the Supreme Court is binding on all courts within the territory of India. Constitutional provisions for Supreme Court. The Indian Constitution provides for a provision of Supreme Court under Part 5 and Chapter 6. Article 124 to 147 in Part 5 of the Constitution deals with the organization, independence, jurisdiction, powers and all procedures of the Supreme Court. The Indian Constitution under Article 124 Clause 1 states that there shall be a Supreme Court of India constituting of a Chief Justice of India and until Parliament by law prescribes a large number of not more than 7 other or additional judges. The jurisdiction of the Supreme Court of India can broadly be categorized into original jurisdiction, appellate jurisdiction and advisory jurisdiction. Organization of Supreme Court. Supreme Court has 34 judges including CJI, Chief Justice of India. In 1950, when it was established, it had 8 judges including the Chief Justice of India. Parliament of India can regulate them through legislation. Seat of Supreme Court. The Supreme Court sits at Delhi. It may also sit at such other places as the Chief Justice may decide. Means the Chief Justice has the power to appoint another location or location as the Supreme Court's seat. Only with the President's approval he or she can decide in this regard. This clause is merely optional, not mandatory. The Chief Justice is appointed by the President of India. Usually, senior most judge is promoted to the post of Chief Justice by the President. The other judges of the Supreme Court are appointed by the President in consultation with the Chief Justice. Powers and functions of Supreme Court of India. The jurisdiction and powers of the Supreme Court of India are wider than court of any other country. It is a court record. It is the guardian of the Constitution and protector of the fundamental rights. It is both the final interpreter of the Constitution and final court of appeal. The powers of the Supreme Court are as follows. Original jurisdiction. By original jurisdiction, we mean that the court hear and receive cases directly from the parties in dispute. This means that not all but certain types of cases can originate with the Supreme Court alone. For example, A. Disputes between the Government of India and any state or states. B. Between Government of India and any state or states on one side and one or more state on the other side. C. Between two or more states. Thus, private persons and corporations cannot file suits in the Supreme Court. Court will not entertain political disputes. Disputes must involve some question of law. Appellate jurisdiction. Article 133 provides for appellate jurisdiction in civil matters and Article 134 in criminal matters. Supreme Court hears appeal in civil, criminal and constitutional matters. All cases that come to the Supreme Court in the form of appeals against judgments of lower courts fall in the appellate jurisdiction. An appeal can be made to the Supreme Court against any judgment of High Court. If the High Court certifies that the case involves substantial question of law as to the interpretation of the Constitution. In criminal matters, an appeal can be made to Supreme Court if the High Court certifies that the case is fit case for appeal to the Supreme Court. Without the certificate of High Court, an appeal can be made to Supreme Court if the Supreme Court grants special leave to appeal. Advisory jurisdiction. The President of India can refer to it any question of law or fact of public importance for its consideration. The court is duty bound to give its opinion on the matter referred to it by the President. However, the opinion of the Supreme Court is not binding on the President. Supreme Court is a court of record. The Supreme Court is a court of record, means its decisions and proceedings are recorded for future references. Suppose if they are not obeyed by any persons, it can punish a person responsible for its violation. So the decisions of Supreme Court are to be admitted as evidently valid and cannot be questioned in any court. Power of judicial review. Since the Supreme Court is the guardian and final interpreter of the Constitution, it can declare any law of the legislature and orders of executive as null and void on the ground of unconstitutionality. The Supreme Court has power to examine only the unconstitutionality of laws made by the Parliament and state legislatures. If they made law within its constitutional power, it cannot declare them as illegal, however unreasonable they may be. If any law or order is contrary to the spirit of the Constitution, it can declare them void or illegal. Any law which is declared as unconstitutional by the Supreme Court cannot be enforced. Guardian of fundamental rights. The Supreme Court also protects the fundamental rights of Indian citizens by issuing various types of writs. It issues writs like habeas corpus, mandamus, quo warrant to etc. to protect rights. Friends, I will make separate video on all these writs such as habeas corpus, mandamus, etc. Next one, judicial activism. The concept of judicial activism gained popularity in 1990s and has greatly contributed to the enhancement of powers and prestige of the Supreme Court. As the executive and legislature organs of government were not discharging their constitutional duties, the judiciary issues directives to various authorities to discharge their duties. Public interest litigation (PIL). Public interest litigation means that any member of public can initiate legal proceedings on behalf of any aggrieved person, especially a poor person who is unable to move to the court. Such cases can be initiated in either the High Court or the Supreme Court. for the enforcement of the constitutional or legal rights of a person or group of persons. In terms of principle of public litigation, the Supreme Court can interfere whenever and wherever any injustice is caused by state action to the poor and caused helpless persons who cannot approach the court. So friends, this was about the Supreme Court of India, its powers and functions. Next video will be on High Court, its powers and functions, which will be coming on Wednesday, that is February 15th. Hope you loved this. Do like, share and subscribe the channel No Spear for more such interesting informative videos. Thank you.